that take place in Russia, saying that this is happening in Germany right now. So the treatment of the Ulm Five in their detention, I firmly believe that was this trial goes on, they should be out on bail. It would be a proportionate position for the crimes that they are accused of. I firmly believe, as do their lawyers, that they should be able to sit uncuffed and confer with their legal team whilst the trial is taking place. And I firmly believe, as we all do, that if they are to be incarcerated, this solitary confinement and everything has to end. But even the location of this trial in a courthouse that was built in the 70s beside a prison to try the Red Army faction sends a message, is about sending a message out to Germans that this is trying terrorism, not political activism. These 5 individuals, Daniel Tatlow-Devally and their colleagues, are not dangerous to any individual in Germany or in any other country. They are expressing their political position in a manner that people may or may not agree with. That is not the matter at hand. It is how they're being treated on remand and in that trial. It does have all the hallmarks of a show trial. It is the heaviest handed response I've ever seen. The fact this is taking place in the largest, most powerful nation and a pillar nation of the European Union is of deep concern. And our call, at the very least, is a modest one, that the Minister and the Irish Department of Foreign Affairs send a legal observer. There is precedent for it. They have done it before in trials in Colombia and in other countries. They have sent legal observers to ensure that the human rights of Irish citizens is being upheld. And we'll be writing to the Minister for Foreign Affairs and asking for that to happen and continuing our pressure. And what we want more media interest. We've been heartened by the level of interest in the last couple of days, but I think if journalists from Ireland are able to go over and see for themselves what we saw yesterday, I think they will come back with the same response and the same feelings, and I think that would help build the pressure up.
Okay, Gurmina Magi as chacht an gédó síos húma sáil chun Casa le Daniel a hain sa frisún, so bhí trúr ag an cuairt sin sa frisún agus beléir nuair thuma an grá na conílacha ina bhfuilte ag fannacht gúil siad úsach, gúil siad crua, agus chuir sé iontas orm, chuir sé búirt níos mú orm. So thuma an bórtha agus tháinig na rá se bhád níos bórthaí chama rá. Tá sé fé trí uair clé an aon lei a gil beag. Ní se ach tí mór fa uairclaig sin uairclaig maidin agus seacha sin tá sé leis hain sa chéal. Chomála sin níl ach uairclaig aige de chuirteoirí chula bhí ní leir sin, tá sé sin fíorheachar mar dúirt Richard ag an tús bhí sé deachar go teacht leabhar bhí sé gur léamh agus thug sé sin rinsemíanaí agus siad am hain mar eag gur chas Richard agus Duncan leis an ambassador gur bin fá gur airthaí sé sin. Nor a dogma an frisún bhí cama ráb sé intach rá agó sí más choláir se huamuid bhí dína an a bhí ag taú le cás an 5 agus leis an Palestine. Ach an sin bhí muid sa chás thuirte agus ar lá sin a ríist eiles léir sé cé chu donna sa tá cuasaí an. Tá si tíhir go balla as glynne, ní siad an labhairt lena gúid dlíadóirí go héasca, cá siad a dhéanana tríd a microfón nó tríd an balla é hain. A chomála sin, bhí me búrtha faoin bailach go rá an astruúcháin ó dhéana ó béirle go Gearmanis. Bhí coppla uair nar nearnú an astruúcháin sin a gceart. Agus géin den a leabhair sin smú ná teangaháin tá agaí, cé chu tábhachtach is atá astruúcháin cream. So duine acab ná zó agus bhí siad sin rá go chóirgamach siad den an bheith ag sí an aclan na dríadúir agus bin ceann go na príomhrudaí a bhí cantéir inné. Agus nuair bhí siad ará sin, bhí siad rá an fágur chóirgamach sé sin sách éasca le déanamh ná mar eag rá 3 microfón ag an bábhairt áitseoirí na dríadúirí. An bailach gur astruú sin ná gur rá 3 caithear. Ní sin a bhí ráte agus beléir Grosha sin mícheart. Ag an buinte sin bhís ag muintir an lochtéisteachta Grosha sin míchrín agus beagnaí rac agus maiálar sin dariú sin. Ach bhí coppla rud mar sin as camerará a fear búrtha faoi sin. Look, I don't want to speak too long because there's a number of us and there's plenty of us to speak. But I have to say I headed over with concern and I came back with a lot more concern for Daniel and for the others. We visited Daniel in the prison on the Tuesday. We had about an hour with him, and I am very concerned about the way that he is being treated. He is 23 hours a day in a cell, 1 hour outside in a yard. He has 1 hour of visitation every single month. And it was quite clear as well that there were difficulties in terms of access to any types of activities outside of his cell. We also know that there were the issues with the books. That he is holding up very strong, but it is difficult for anybody to be in those type of circumstances. Then we obviously headed to the trial on the Wednesday, and I will actually say, and I'll be honest about it, like I was shook coming out of that prison, thinking about the conditions that he was in. There's no question, and I think anybody here who would go visit Daniel would feel the exact same, and that's why I think it's important that we use our voices. Then on the Wednesday we had the trial itself. Like it's hard to explain unless you see it, but it's a physical glass wall whereby the Ulm Five are unable to speak directly and easily communicate with their lawyers. Some of them, and I can't remember which, had raised the issue of the fact that they find it impossible to hear what's going on in the trial as well as liaise with their lawyers while they're effectively shouting through a wall to their lawyers or through a microphone. I was also deeply concerned at the level of translation. My mother's German, so I understood what was happening as part of the trial, but the translation at points were inaccurate, and that is concerning. So as an example that I just gave, Zoe raised the issue of the fact that, there are 3 microphones at the tables of the lawyers. That was translated as 3 chairs. That's inaccurate. And it was because the gallery, I suppose, kind of kicked up a bit of a fuss, that was then restated. I think that Duncan makes an excellent point. Stammheim, for anybody with any understanding of German history, it gives you a shock. When you hear that word. It is where the Red Army faction trials happened. It is also where Red Army faction people died. Ulrike Meinhof, for example. So it is, for anybody in that context, I have to say it is who understands that context, I think it is particularly concerning. I do want to say that the people around the Ulm 5 have been excellent. There's a great support base there. There's a great support base when we landed in the airport, when we came out of the prison, and indeed at the trials themselves. So I think that is very good. But I mean, I think absolutely at the very least we need to have observers there. This is an Irish citizen on trial. The family, the lawyers, and now us, we are saying that we have concerns in the way he's being treated.
Thanks. So I'll move these over for Patricia.
Well, maybe you did leave them for questions later. I think.
Yeah.
Yeah. Well, you can move them over a bit.
I'll move them slightly.
I'll speak loudly.
And I'm taking it, Barry, just because. I'm just taking an order to people.
You were late, Barry. So.
No,
well, actually, we may have made a mistake.
Yes, I had 12 then.
Sorry, it was the train. It was the train.
So there was a confusion because originally we'd said 12 and we changed it to 11:45. So apologies to Barry.
It's probably relatively unusual, noting that Barry's here, to have a cross-party delegation that is both government and opposition, and I think that points to the shared concerns that we have, and this isn't sort of a partisan issue necessarily. There will be people who don't agree with the concept of direct action. There will be people who think direct action is necessary. There are lots of people who are very distressed about what's happening in Palestine, as we well know, and lots of people who wish countries, including EU member states, were doing much, much more. So taking aside, how you conceive of the actions of the Ulm Five, whether you agree with what they did or what allegedly did or what they allegedly didn't do, human rights and rule of law and democracy are the tenets that we sign up to as EU member states, but also as global citizens, as members of the UN. And we had, before we went out, and continue to have even more so, serious concerns about the right of a fair trial. We have serious concerns that Daniel's rights and the rights of the Ulm Five under the European Convention for Human Rights are being undermined as it relates to the right to a fair trial. We have serious concerns about their ability to appeal whatever the trial is, because it isn't being, there is no public record of what's happened. You know, the right to appeal is kind of fundamental. You know, we would expect that for anyone going through the criminal process. We have seen an inconsistent application of the principles that we, as an European member state, have signed up to. We've seen that when it comes to international law versus Ukraine and Palestine. We are seeing that when it comes to the idea of human rights. Like, we are Ireland and Irish Aid. We do fantastic work when it comes to human rights in Latin America, in Africa, in Asia. But we can't always be lecturing to the global south about their human rights record and what they're doing if we're also. And if we have concerns that a friend, Germany, an EU member state, a friend in the European project is undermining the rights of our citizens, we need to identify that. And we need to have dialogue about that. And that is what we're asking. It's what we've been asking since all of us independently have been raising it with Helen McEntee in the Department of Foreign Affairs, requesting trial observation. The Department of Foreign Affairs have told me that that would be considered interference and that they're not able to do that under the Vienna Convention. However, there's a document called the European Union Human Rights Defenders Guidelines. Ireland has signed up to it. All EU member states have signed up to it. And under those guidelines, there's actually a recommendation for trial observation, that we would go to other parts of the world. We heard about Colombia. When I was living in Uganda, an Irish official from the Department of Foreign Affairs conducted a trial observation mission for a human rights defender called Nicholas Apio. It is something that is done. So this idea that we don't do it because it's an EU member state and we don't do it because it's an ally in Europe suggests, again, this two-tier approach, this idea that we will hold some countries to account for their human rights record, for their standards and rule of law, but we won't hold other countries to account. What's the point then? What's the point of having principles? Every country has the ability for slippage. Every country has the ability to, in times of crisis or in times of difficulty, perhaps not do what they would normally do, perhaps not have the same standards for every group of people, in every trial, in every case, in every human rights situation. And we have a duty to check that and to hold each other accountable. And that is what I suppose we are requesting the department do when they conduct independent trial observation. In order for them to see what is happening, they have to go be there on the ground and conduct that. There is precedent. There is a role in the EU Human Rights Defender Guidelines for them to do that. We are not asking them to break the rules. We're not asking them to break convention or what is already written down and recommended that they've signed up to. We're just asking for consistent application. And we're asking for them to observe whether or not the rights of an Irish citizen are indeed being violated, as we think that they are. No bail, no recording of transcripts, 23 hours of solitary confinement, no note-taking for us, parliamentarians. There is a sense that the handling of this trial is completely disproportionate to what the Ulm Five are allegedly said to have done. We have seen Palestinian activists in large parts of Europe for their actions to be dealt with disproportionately. It is not okay. It's not the norm, and we need the Department of Foreign Affairs we need them to take action on this. It can't just be the Palestinian activists, it can't just be Daniel's family, it can't just be the lawyers. Human rights experts are saying they're concerned that the European Convention of Human Rights is being violated for these citizens. Are we okay with that? Can we accept that? We believe that shouldn't be allowed.
Thanks, Patricia. And finally over to Barry Ward. I'll move these. Yeah.
Thanks very much. Just give me 1 sec.
Yeah. I suppose I'm in a slightly different position to most people at this table, not just because I'm the only member of a party that's in government, but I'm also a lawyer, a criminal defence lawyer with 20 years' experience of visiting people in prison, representing them in criminal trials. And I come at this not with any attempt to condone what happened, and I probably am also... I'm somebody who I don't believe the criminal damage constitutes legitimate protest. I make no judgment to that one way or the other. It's not my place to make a judgment. So what I'm looking at this is not with a view to making any value judgment on what did or didn't happen, although I do note that there's enough dispute about the facts of what happened, more about the character of what happened. But the point I make is, irrespective of that, what I am very strong in my mind on is the fundamental rights that we expect people to enjoy in not just the European Union, but the Council of Europe countries, the countries that have signed up to the European Convention on Human Rights. There are basic standards, and obviously Germany has a different legal system to ours, and there are differences there. I see that myself from my own practice, the differences there. I don't have any difficulty with those differences, but I do have difficulty with what I saw as being far short of the minimum standards we expect for fair trials. And so to me, there are two aspects to this. The first is the incarceration element. Obviously, the German authorities have decided to pursue this on the basis of particular terrorist legislation they have to deem people in particular situations to be a different category of case under their law. They're entitled to do that, but I would call into question the objective basis on which they have done that. So if you look at, for example, in the same court house where we were this week, there was a trial going on in the same building of other people who were also being treated under the same terrorist legislation, but who were involved essentially in an armed struggle to take down the German state. The categorisation of them as being the same as the people who were in the court at the Ulm 5 is entirely, they're incomparable. So those people discharged firearms in the course of some of their so-called protests. They injured police officers. There was an entirely different character to their, if you want to call a protest. What you're dealing with the Ulm 5 is people who went into a factory, caused a significant amount of damage. My understanding of their case is that they did so on a legitimate basis. I make no judgment on that. But the important difference is they recorded what happened. Those recordings are available. They waited at the scene until the police arrived. For them, part and parcel of their protest is the trial itself and the exposure of these issues before a court. The notion that they are likely to leave Germany in those circumstances is a nonsense. And so I find the objective nature of a decision not to grant them bail very strange. But even if you accept that the German authorities have, of course, the right to refuse them bail, as long as they do so in accordance with law, I then turn to the conditions in which they're kept. And you've heard the fact that Daniel Tatlow-Devally, for example, is kept under a 23-hour solitary confinement regime, something that is not acceptable in my view. He has no opportunity to socialise with people in the prison in real terms. He gets 1 hour a day in a closed concrete yard with no greenery. The windows in the cell are not transparent glass, so he cannot see out of the cell. He cannot see anything other than the strength of the daylight, essentially. The cell itself is 5 metres by 2 metres. There is not enough room for him to exercise in there. He has occasional and inconsistent access to a gym facility within the prison, which is, by all accounts, inadequate. In addition to that, there are different aspects of the prison regime, including paying for food, for example, which I would question. But leaving them all aside, I think he is in a really difficult position because he's in such an oppressive regime, and there doesn't appear to be any objective basis for that. We had an opportunity to visit him on Tuesday. I was very impressed, actually, with how he's dealing with the situation. I think he's clearly a very strong, intelligent individual, and that helps. To have a mind that can be active during that time obviously helps him. But he has been there now for the best part of 10 months, and that is an extremely difficult position for him to be in. And at the moment, the trial is scheduled to continue until January of next year, so that will continue apparently until then. And I think, A, it's without objective basis, but B, it is in contravention of what I would think are minimum standards for the detention of a person in prison on remand. The second aspect for it then is the trial. I think one of the most important things in any criminal trial from a judicial perspective is that the judge is consistent and appears, at least, to be fair. We don't know what's inside judges' heads, but there must be the outward expression of fairness and equality within the courtroom. What I saw yesterday in Steinheim did not show that. What I saw was, I likened it, speaking to somebody afterwards, to being like a teacher who had lost control of the classroom. There was no consistency to what we saw in court yesterday. And in fact, the courtroom layout even, I have a real issue with the fact that the defendants do not have access to the lawyers in the course of the trial. They cannot communicate privately with them, or indeed in real terms, because they are behind. If you imagine the courtroom, it's set out into three parts. There is the main court, there is the visitors gallery, and there is a corridor within which the 5 defendants sit with police officers or particular police personnel. In order to speak to their lawyers, who might be 2 desks away from them inside the court, they have to go to a grill in the glass, get the lawyer's attention and then speak to them through that. So there's no privacy, there's no protection of their confidentiality, and it's extremely difficult for the lawyer to continue to be engaged in the trial and to take instructions from the client. It is inconsistent in my view, particularly where there is no basis for suggesting that there is any propensity to violence with the people who are on trial. There's no demonstrated instance of that, so I don't think there's a basis for it. For us then in the public gallery, we are behind a massive wall of bulletproof glass. Notwithstanding that, I was not allowed to bring a ballpoint pen and paper into the court to take notes. I don't know what damage they thought I would be able to do with a ballpoint pen from behind a bulletproof screen. I wasn't allowed to have my belt either, not that it's a weapon of choice or anything like that, but there was a level of security going into the court, which is fine. Everybody needs to ensure that everybody's safe in the courtroom. But then having gone through extensive airport-style security, an extensive pat down in a private room, shoes taken off, everything examined, nothing was returned to us. The only document I had going into court was my passport. Now, I don't see the justification for that, and it affects the transparency of the trial as well. One of the major issues in terms of the fairness of this trial is that there isn't a transcript. There isn't a recording of what's going on in the courtroom. Again, this is a minimum standard because if any party, defence or prosecution, chooses either to appeal the result of the trial or any ruling within the trial, and I'll come back to that in a second, they have no opportunity to have an independent and verifiable record of what was said or what transpired in the court. Notwithstanding the fact that all of the audiovisual equipment is there, when a witness gives evidence, it's into a microphone. There are translators in the courtroom who hear everything and translate. Although I know that there have been issues with translation. I don't speak German, so I can't say that I heard that myself. But the witness is broadcast onto a screen up on the wall in the courtroom. So the facility is there to record something, but a conscious decision has been not to do that. So the record of what happens in court is prepared by a staff member of the judge. The judges, there are 5 judges, there's one presiding judge, and that, I understand, can be changed unilaterally by the presiding judge. So it is not a reliable, or it may not be an accurate record of what's happened, which makes any appeal after the fact very difficult. And I said, if anybody wants to appeal a ruling, well, we were present yesterday when a number of applications were made by defence parties for things, for example, to be allowed to sit with their lawyers. That ruling was there was no ruling on that in fact at all. She didn't make a decision, or the judges didn't make a decision on that at all. It was just allowed to kind of go into abeyance. There was another part of the trial when one of the defence lawyers purported to read the wording of an arrest warrant issued in relation to Benjamin Netanyahu by the International Criminal Court, a court to which Germany is a signatory. He sought to read out the arrest warrant text, which is in English. He was prevented from doing so. There then was a long recess when the judges considered his request to do so and came back and said, they initially said he couldn't do it at all, then they said he could read it in English only yesterday, but that after that there would be nothing else would be read in English. The judge initially suggested, for example, that he could read it but it wouldn't form part of the trial, wouldn't be included in the record of the day. This is notwithstanding the fact that prior to yesterday, it was possible to read things out and have them translated into German. So that's what when I talk about the consistency issue. There is not a consistency issue within the court, and you can see the frustration of the defence lawyers who are sitting there that they are making these applications. They get no sense from the bench that there is actually a listening ear for those applications, and in several instances that I witnessed, there's simply no ruling at all. The application is made and then it's allowed to lapse. So I would have very serious concerns about the fair trial nature of what's going on. And I come to this as a lawyer with 20 years experience, and that is the reason that I am here. It's not to justify anything or to condone anything or to make any judgment one way or the other. But as an Irish citizen abroad, or any European citizen, or any citizen of a country that's part of the Council of Europe, they should be entitled to those basic procedures. And from what I saw, either in the context of the detention or the trial procedures themselves, they were absent. And I think that is a real problem. And like others here, I'll be raising it with the Minister for Foreign Affairs.
So, over to people for questions. Just two of the details, actually, just to throw in, just for mention, that haven't been mentioned. There was a motion put forward by the defence on the issue of the access of the public gallery and parliamentarians to pen and paper. That was also never ruled on. But they made the point, first of all, that it was unprecedented in the German legal system for the public gallery not to be allowed to have pen and paper to take notes. And that even if the judge wasn't willing to concede on that, would the judge concede that parliamentarians didn't represent a threat to public safety, and on that basis allow them to have pen and paper? and she didn't even respond to it. And another little small detail just gives you so they put forward an application on removing the glass barrier. There was no ruling. Glass barrier that is not present in the trial that was mentioned earlier. And when the prisoners were brought in through the glass corridor, the guards stood at the end of the glass barrier so that members of the family and friends couldn't even put their hands up against the glass or get in proximity, just to sort of show a bit of human communication to their loved ones in the corridor. To just physically block it. It was just vindictive prevention of even kind of most elementary contact between those in the gallery and those in the glass thing. And points were put, an application was made by the defence that this architecture was totally unnecessary and unprecedented in the context of this type of case. And there was no response from the judge.
Cash ditcha by word. In ye or tu ar in brethach the when to Kershias or in trio mar hio real. In far rusar to a termaship.
Well, an fibeatán ná nuair atá ag féchan ar an méadatóir siúla agus mar dúirt na nóid a hen. Caithfidh go mbeadh muinní na gach céine sa tríal go bhfuil an brethebh nó na brethúna an go bhfuil corm na féine idir an cosantóir agus an uncúsah. Agus le táta ag féchan ar mar sin, ní dóilm go sé an, agus ní sílam go sé an tuisnach bhfuil an brethebh no, well, an brethebh tuis go bhfuil an príomhbreithigh ag déanamh an caint an tamar fad. Ní raibh foiachráite ag na brethúna eile. Ní nuair atá siise ag labhart, ní sílam go sí ag féchant ar na hirirtas a bhí déanta ag na cosantóirí. Ní siad ag féchant orthú mar fear iritas. Go raibh si chun cinenne dhéanamh taobh nó taobh eile. Níor ghlach sí le éon iritas amháin ó na cosantóirí nar bhí mise an agus ceapan nach bhfuil éon cinenne déanta orthaí. So sin an fáid, má tá siad chun leanúint a ráid mar leis an tríal mar seo, gan bheith ag féchant ar na fíor ceisne tá an. Caiithúra nach fíor riile tá an ach seo tríal mar deirmar. So sin an fáid agus mátá si chun leanúint mar seo ní féidir le muoine na bheith ag aine faoi an tortha tucha amachchas an tríal.
Ag apantu go bhfuil an brethebh cléanta.
Well, ní féidir le mé sin a rá ach cé go fada sa chunig mise éonrad sa cuairt. Bhí si dechar rá go raibh an chothraíocht sin idir an uncúsah agus na chosantóirí.
Could you do translation?
Sorry.
Brief.
What I'm saying is, so it has been described, and I have agreed with this definition, that it's a show trial. And the reason I say that is that as you look at the decisions and the conduct of the presiding judge in court, there are 5 judges, the 4 assistant judges, 2 of whom are lay people, do not really involve themselves, as far as I can see. The presiding judge makes all the decisions. But there is no impression, as you're looking at what's happening, that she's taking on board applications from the defence in a sincere or genuine or equal way. And so in order for anybody to have confidence that it's a real trial, that it's a trial that is doing what it's supposed to do in terms of assessing the issues and make a judgment, you'd have to have confidence that she is doing that. We got no show in what we saw that there was any real balance, and that's why I would conclude that there is a show trial element to it.
I just asked 2 other questions. One, apparently in Germany they forbid full transcripts and broadcasting or recording, except in very exceptional cases. And that's been an issue and a controversy there for years, but that's the scenario. The other, if you could respond to that, the other one is, why do you think the Department of Foreign Affairs has refused consistently to send an observer?
I mean, on the people may know more detail. What I can say is that the legal defence teams did say to us that the it's being taken, given that there's no transcripts or records. I can't honestly speak about
The norm.
The norm in regard to that. But what the defence teams made absolutely clear was that the refusal to allow the public to take notes was unprecedented. And secondly, that the general conditions of the trial were extraordinary, given the nature of the charges, that this was not normal. And in fact, it might be worth, they noted that there are 15,000 cases currently underway against pro-Palestine activists in Germany. And the particular severity of the detention regime and the character of the trial in the case of the Ulm 5 is out of kilter with how most of those cases are being dealt with. So we're dealing with a quite extraordinary, draconian situation, is what the defence teams told us.
And I might just answer that question on, the department. I mean, so the department have responded to me, and I'm sure they've said to other reps in other capacities that under the Vienna Convention, which outlines diplomatic norms and practices, that they can't interfere in trials in other countries. And I just want to make it clear that certainly our attendance there wasn't interference. There is a trial observation is a thing. It is a thing that people do. It is a norm. Countries do it all of the time. They particularly do it when it comes to ICC cases, which I'm sure Barry can attest to, and European Court of Human Rights cases. It is something that is habitually done. So that is the rationale that they'll give, and we can come up with a list of examples of places where the Department of Foreign Affairs have done trial observation in other countries, but largely in the global south. Largely not in European member states. So I would get a sense that there's a desire not to, there's a feeling that we shouldn't be doing that when it comes to our neighbours. We shouldn't be doing that when it comes to our closest allies. But just to reiterate the point that I made previously, we have a duty to hold each other accountable as individuals, as states in a collective union, and make sure that we are all practicing what we're preaching and we're all upholding the principles that we've signed up to. So I don't think that just because something's happening in Germany, or if it was in Hungary, or if it was in Uganda, or if it was in Colombia, that we should be behaving differently, and that we should be treating that we should have a tiered response of how we conduct trial observation, that we'll do it in some places, but we won't do it in other places. So I suppose, I've raised the issue, and I'm sure we all have, but I've consistently asked about the EU Human Rights Defender guidelines. I haven't gotten a response from the department on, and there's some EU member states that were happy to do trial observation and others that were not. Again, it's about